Thanks a lot for that, Tracy. And yeah, good afternoon, everyone. My name's Chris and I'm a legal counsel at Bovis, and I'm also a volunteer leader at the JCT Young Professionals Group. And today we're going to look at project management. So I guess before we start, do we have any project managers on the call today? Perhaps not.
I'm a building surveyor, but I work in a project management capacity for office fit out.
Okay, brilliant. So yeah, I think a lot of the content we're going to cover today will be probably directly relevant to you, but particularly some of the lessons that we're going to look at from some of the case law, I think is going to be applicable to kind of construction professionals across the board. So I hope it'll be useful. I think if there is one thing I want you to take away from today's kind of session, it is the lessons from the case law. So we'll be getting onto that shortly. Just by way of housekeeping, before we start, this kind of presentation is delivered in my personal rather than professional capacity on behalf of Bovis and does not constitute legal advice. And as Tracy said, we should have some time at the end for any questions. So. Right, so today I thought what we would do is we'd take a look at actually what project management is, kind of what we're not referring to, and some of the typical kind of responsibilities that project managers often take on. Then I'm going to do a kind of high level kind of legal bit. We're going to look at kind of standards of care. We're going to look at reasonable skill and care obligations and absolute obligations, and touch on kind of fitness for purpose obligations as well. And then I'm going to cover three, I think, key cases for project managers. So we're going to look at the Pozolanik v. Brian Hobson Associates case, which is basically an insurance case which has lessons for project managers regarding ensuring that a professional indemnity insurance was in place. We're going to look at the case of Ampleforth, which was a case that centered on letters of intent and the liability of a project manager for not putting in place a building contract. And then we're going to look at the Sweet case, which that case didn't actually involve a project manager. It was an employer's agent. But that case was to do with kind of the provision of a performance bond and kind of the drafting that was in the contract and the scope. And I think that's got lessons for project managers as well. Right. So as you probably see, what I've done here is I've kind of listed out some key definitions of project managers from the kind of Association of Project Management and the Chartered Institute of Building. Most of them are actually kind of outdated now. So you'll see attempts to kind of define project management in the 2002 and 2010 codes of practice. Whilst it is slightly out of date, I think the 2002 one's quite a good kind of definition. I think it's quite clear cut. So project management is the professional discipline which separates the management function of a project from the design and execution function. And kind of building on this, the latest version of the code of practice for project management for the built environment, which was the 2022 version, provides that it's crucial to put the client at the center of decision making. I think most project managers are typically appointed by clients, and it's got kind of 8 key themes woven into each chapter to help to ensure they're kind of embedded throughout all decision-making processes at every stage of the project. And that's quality, sustainability, value, productivity, leadership, collaboration, knowledge, and risk. For the purposes of this presentation, we're not referring to kind of project managers under the NEC. They obviously play a crucial role in NEC contracts and facilitate kind of collaborative working to cultivate kind of team spirit and drive that NEC approach. But that's kind of what we're not referring to that for the purposes of this presentation. So what are some of the core responsibilities on project managers? So ultimately, it does depend on what's in the contract and in particular what's in the scope. So the Royal Institute of Chartered Surveyors publishes a kind of template scope of services It's kind of like a tick box kind of document which works with its standard and short form consultant appointments. And the latest version from 2022 includes various subsections which are quite indicative of the kind of things that project managers do. So you can kind of read those out on the screen. It's kind of general services all the way to like kind of contractual BIM, and kind of additional services for kind of prime cost contracts and the like. And the kind of typical kind of contracts that you would expect to see project managers engaged on is basically services type contracts. So typically like consultant agreements, or you might see kind of framework and call off arrangements. So now, as I said at the start, we're going to do like a high level kind of legal section. So we're going to look at what we mean by standards of care and kind of a high level look at some kind of typical legal claims, kind of breach of contract claims and negligence claims. And we'll look at, reasonable skill and care and absolute obligations and how they might be implied or kind of expressly dealt with. So what do we mean by standards of care? So basically, in layman's kind of terms, the standard of care is the legal kind of yardstick for acceptable behaviour. Fall below it, and you might, as we said, be liable for kind of negligence or breach of contract. So breach of contract claims. I'd appreciate for some of the lawyers in the audience that this is lived up. This is, I'm not telling them anything new here, but I think this would be useful for the non-lawyers. So at a really high level, in order to bring a breach of contract claim, you need to establish that basically one, that there's a contract in existence. And generally that means establishing that there's been an offer to do something, an acceptance of that offer, some form of consideration. So that's why you'll often see contracts for a peppercorn or a pound. It's to meet that consideration kind of aspect, and an intention to create legal relations. And contracts can either be written, which is usually advisable, so a lot more clear, or they can actually be created orally as well. So in order to bring a breach of contract claim, you also need to prove that the contract was breached and that the loss suffered was as a result of that breach. And losses generally fall within kind of direct and indirect kind of categories. The case of Hadley v. Baxendale is a key case here, and that established a test for recoverable damages in contract law. Basically, in summary, that judgment held that losses must either be kind of arising naturally from the breach in the usual course of things, or reasonably within the contemplation of both parties at the time of contract formation. So alongside contractual claims, project managers may also owe a duty of care in tort. So a tort is kind of a civil wrong, other than a breach of contract, that causes a claimant to suffer loss or harm, resulting in legal liability for the person who commits the tortious act. So the most common tort that we kind of come across as construction lawyers is the tort of negligence. And to succeed in an action for negligence at common law, is well established that a claimant must prove that the defendant owes it a duty of care, that the defendant has breached that duty, and that such breach caused the claimant to suffer loss. And in order to bring a claim, there are basically four main ingredients. One of the landmark cases was the case of Donahue v. Stevenson. And one, you need to establish a duty of care. Two, there needs to be a breach of that duty. Three, damages need to have been caused by the breach. And four, kind of causation and kind of foreseeability of damages. That's very high level. For those interested in learning a bit more about negligence in more detail, I'd probably advise them to look at the case of Caparo v. Dickman, 1990, which was kind of modern duty test. I think there was a Wagon Mound case which dealt from 1961, which dealt with foreseeability and remoteness of damages, and the case of Bolam, 1957, which was a professional negligence case. So basically, by way of an overview, there's two typical two types of standard of care, really. So I think the first one we're going to talk about is reasonable skill and care. So reasonable skill and care basically means that a consultant agrees to use reasonable skill and care in performing their services. So this could be a lower standard than a fitness for purpose obligation, because for example, a professional consultant can avoid liability even if, for example, its design is not suitable for its intended use. And as we'll probably see in the next slide, reasonable skill and care obligations can either be express or implied. This is in contrast to a fitness for purpose obligation, which is a type of absolute obligation. And that means that basically when completed, a project would be fit for its intended use. This is obviously quite a high standard, because the professional consultant effectively is almost kind of guaranteeing that its design will be suitable for its intended use. And basically a fitness for purpose obligation is an example of an absolute obligation, different from reasonable skill and care. Other absolute obligations include for example, you might get an absolute obligation to comply with statutory requirements, for example, health and safety laws, etc. In the kind of UK construction industry, reasonable skill and care obligations are more typical, whereas fitness obligations are slightly more rare. And there's kind of an issue, basically with fitness for purpose obligation, there's a consideration about whether there's an issue with professional indemnity insurance coverage. And a professional consultant or a project manager should probably check with its insurers before agreeing to anything that kind of looks like a fitness for purpose obligation. Slightly kind of beyond the remit of this presentation, but for those interested, there was a case in 2017 called Hogarth v Eon, which was a Supreme Court case that considered fitness for purpose obligations taking precedence over a less stringent kind of reasonable skill and care duty if there was a conflict. So, as I said, so you can have kind of implied and express reasonable skill and care obligation. So in the absence of kind of express agreement, a duty to act with reasonable skill and care may be implied into an appointment under Section 13 of the Supply of Goods and Services Act. However, it's kind of best practice and more usual for a professional appointment to include a kind of express clause setting out the required standard of care. This kind of basically avoids any doubt about the standard that is expected, and kind of would override the kind of implied duty, and it's a lot more clarity between the parties. So there isn't, in fact, a universally accepted wording for a reasonable skill and care clause. Kind of in the most simple clauses, the professional consultant agrees to perform the services with reasonable skill and care. And you can get various kind of variations of this wording. I think the JCT D&B 2024 clause 217.11 refers to the reasonable skill and care in such design to be expected of a qualified and experienced architect or other appropriate professional designer undertaking the design of works similar in scope and character to such design of the works. That clause actually, I think the 217.12 also actually includes a fitness for purpose kind of exclusion. In addition, the JCT has a JCT consultancy agreement, public sector 2024, which also includes kind of similar drafting, and that refers to the consultant exercising the level of skill and care and diligence reasonably to be expected of a consultant holding itself out as competent to take on the performance of the services and experienced in projects of similar size, scope, and complexity. You may also see a requirement to use the same level of skill and care as would be expected of a competent professional operating in that specific sector. So an example of this is Clause 21.2 of the NEC 4 PSC contract, which refers to the consultant's obligation to use skill and care normally used by professionals providing services similar to the services. And as we saw above, you often see a requirement parties to act diligently. So as well as the JCT D&B, the REBA Professional Services Contract 2020 with 2024 amendments refers to a consultant exercising reasonable skill, care, diligence. So what kind of constitute diligence is very much kind of fact and context specific. But yeah, there's various ways of basically drafting the reasonable skill and care clause. You often also see a kind of express warranty from the professional consultant that it will comply with the standard of care. So you might be asking how might the reasonable skill and care obligations interact with kind of other duties? So the kind of the relationship between the professional consultant's skill and care obligation and its other contractual duties isn't always clear. So it basically depends on the precise wording within the appointment. For example, a professional appointment may expressly distinguish those duties that must be performed with reasonable skill and care from those that where a different standard applies. For example, an appointment may impose a reasonable skill and care obligation except where any statutory requirements impose a higher standard, in which case that higher standard applies. Or you might get a professional appointment simply kind of identifying reasonable skill and care obligations as a standalone duty, perhaps listed alongside other obligations with no kind of obvious hierarchy. There's a bit of a kind of interplay there. So yeah, that was kind of as the amount of detail I wanted to go into for the standards of care and the kind of the typical legal claims. But as I said from the start, I think the key thing to take away from this presentation is some of the lessons from the case law. So there aren't a huge amount of cases involving project managers, but the three that I think we're going to cover for this presentation is, as I said, Pozzolanic. So that was a project manager owing a duty of care to the client to ensure the PI insurance of the consultant was adequate, or a failure to do that. The Ampleforth case, which was letters of intent, it looks at the liability of a project manager in respect of its failure to advise its clients to put in place a building contract. And the case of Sweet, which kind of centered on an EA who kind of failed to procure a performance bond, and the kind of case kind of centered on the kind of drafting within that contract. And I think some of the facts are quite dense for some of these cases, but I've kind of set out some of the lessons, and I think that's really kind of what I want you guys want to take away today. All right, so the Pozzolanic case. So I'm going to probably set out the facts first. So the claimant employer, Pozzolanic Lightag Limited, was a wholly owned subsidiary of Boral UK Limited, and they wished to have built a dome for the storage of pulverised ash at Fiddler's Ferry power station. The defendant was Brian Hobson Associates, who were a firm of structural and civil engineers and were engaged to carry out services for Pozzolanic. And Horrell Harrington was a contractor engaged to complete the works, and they were appointed under a JCT 1980 contract with contractor's design portion. So the design of the dome was carried out by Horrell Harrington and checked by one of its consultants, Associated Structural Consultants Limited. And in April 1992, the dome collapsed. So Pozzolanic contended there were losses of kind of around £600,000. And the collapse was found to be caused by defective design, which would kind of ordinarily be covered by professional indemnity insurance of the type kind of required by clause 21A1 of the JCT 1980, which I've kind of pasted a kind of extract of on the PowerPoint there. So Horrell Harrington, they later became insolvent. So the only kind of professional indemnity insurance in place was that of Associated Structural Consultants Limited. Pozzolanic submitted that Horrell Harrington was not insured under this policy, and Brian Hobson Associates was negligent and in breach of its contractual duty in failing to ensure that the indemnity insurance was in place, which would cover liability of Horrell Harrington for the defective design. And the case basically centered on the interpretation of the scope of Brian Hobson Associates. So there were kind of various discussions about contracting structure, but ultimately it was decided that Horrell Harrington would be directly appointed by Pozzolanic, and they would retain ASC to do the design. And Hoyle Harrington contended that Pozzolanic would have the benefit of its PI. So under Brian Hobson Associates appointment, their services included providing any necessary negotiations with Hoyle Harrington and contract and project management of the two civil contracts, both dome and groundwork. So Mr. Rhodes of Brian Hobson Associates invited Hoyle Harrington to a meeting to discuss contract conditions. And in advance of that meeting, following Hoyle Harrington's request, Mr. Rhodes sent an extract of clause 21A of the contract. In his reply, Mr. Rhodes stated, and this was kind of central to the case, regarding clause 21A, your consultants, ASC, have probably got professional indemnity insurance cover, which meets the specification. So when we come to the judgment, you'll see that was kind of fatal for Brian Hobson Associates, that very comment. But prior to entering into the contract, there were kind of various discussions about insurances, and ASC were asked to confirm the insurance arrangements. On the 2nd of July, ASC confirmed by phone call with Pozzolanic regarding kind of confirmation of public liability insurance and employers' liability insurance, but nothing was said about professional indemnity insurance. And then on the 9th of July, Brian Hobson Associates received a copy of a letter from insurance brokers confirming cover regarding all risks, property, employer, and PL cover. They separately received a copy of the schedule attached to the PI policy, which only named ASC as the insured. And on the 10th of July, prior to entering into the contract, Pozzolanic asked Hoyle Harrington for evidence of PI cover and to have a form completed by its broker. Enclosed within this letter was a pro forma certificate related to all insurances required by the contract, except in relation to design risks. And Pozzolanic sent a copy of this letter to Mr. Rhodes at Brian Hobson Associates. So that action on the 10th of July is also quite central to the judgments, which I'll get onto shortly. So quite dense facts, but we'll kind of condense the kind of lessons when we look at the judgment. So the court was asked to basically determine various points. So the first one was, did Brian Hobson Associates owe a duty to Pozzolanic to take reasonable care to ensure that, as required by clause 21A1, there was in place insurance which would cover Hoyle Harrington's liability in respect of his obligations under clause 2.6 of the conditions of contract. And the judge found that this was the case. So yes, basically Brian Hobson Associates' original letter dated 6th of June expressly included contract and project management, and kind of industry practice confirmed that project managers must ensure that contractors comply with insurance obligations and not merely act as a post box. So the code of practice at the time, which was the 1992 version, was reviewed alongside kind of various discussions regarding whether Brian Hobson Associates was a project coordinator or not. So there was a key kind of, I've basically extracted a key paragraph from the judgment which summarizes it quite well. So if a project manager does not have the expertise to advise his clients as to the adequacy of the insurance arrangements proposed by the contractor, he has a choice. He may obtain expert advice from an insurance broker or lawyer. Questions may arise as to who pays for this. Alternatively, he may inform the client that expert advice is required and seek to persuade the client to obtain it. What he cannot do is simply act as a post box and send the evidence of the proposed arrangements to the client without comment. So basically, the project manager has to act in a proactive manner. The second point was the question for the court was, had Pozzolanic proved that there was no insurance in place to cover Hoyle Harrington's liability under clause 2.6? The Schedule 2 ASC's policy clearly stated that the insured was ASC and nobody else. And the letter dated 12th of July 1991, which was sent by ASC to Pozzolanic, showed clearly that the policy covered liability on the part of ASC and no one else. The next question was, if there was no insurance in place, was the real or effective cause of the loss Pozolanic's own failure to ensure that the relevant insurance was in place. And that was found not to be the case. So ASC's kind of PI policy unambiguously insured only ASC. Mr. Tucker, who was acting for Brian Hobson Associates, argued that it was in fact Pozolanic's own actions, and specifically writing the letter of 10th of July that we mentioned in the previous slide, and then failing to investigate further, which was the actual real cause of its loss. So he claimed that this kind of broke the chain of causation and amounted to a novus actus interveniens, which was a kind of a Latin term meaning an intervening act, which effectively kind of removing Brian Hobson Associates' responsibility for ensuring kind of adequate PI insurance. But that judgment was that argument was kind of rejected by the judge. The court was then asked to look at whether Pozolanic contributed to its losses by contributory negligence, and again that was rejected. So Pozolanic reasonably relied on Brian Hobson Associates' kind of professional advice as their project manager, and there was no duty to second guess their kind of project manager in that regard. The judgment said that Pozolanic had no reason to doubt the advice that he had received from Mr. Rhodes. He did not have the expertise himself to form a view on the kind of question whether ASC's insurance policy would cover any design liabilities of Horrell Harrington, and basically had no reason to kind of doubt the correctness of the view expressed by Mr. Rhodes on that point. So basically, the TCC judge basically held that the project manager was liable to Pozolanic for not ensuring that the kind of the PI policy was in place for the project. Right, so what were some of the key lessons then? So I think the key lesson from this case was that there was basically a positive duty on the project manager to ensure insurance compliance, and simply kind of forwarding the insurance certificates or schedules and just acting as a post box was not adequate. You kind of need to be a lot more kind of proactive. You need to understand what the contract requires, and you may have to advise or persuade the client whether the actual policy responds to the contractor's liability. As we saw from this case, kind of Brian Hobson Associates' fatal error was Mr. Rhodes's facts stating that ASC's cover probably met the requirements of clause 21A1, and this kind of induced reliance and destroyed any contributory negligence claim. And as we saw from the kind of preceding kind of slide, as the judgment said, if you lack insurance expertise, either obtain specialist advice from a broker or lawyer, or inform the client explicitly that they need to do the same themselves. Another issue with this kind of case was obviously you can't make assumptions that subcontractor PI policies do not they basically do not automatically cover the main contractor, and I think your scope needs to be crystal clear about what it is you're required to do in respect of insurances. So that was the Pozolanic case. So the next case we're going to look at is the case of Ampleforth Abbey Trust v Turner and Townsend Project Management Limited. So between 2000 and 2005, Ampleforth Abbey Trust engaged Turner and Townsend as project managers for 3 boarding houses, kind of construction projects at Ampleforth College, with the third aspect of that project being the H5 Works, which was a £5 million student kind of a girls' accommodation block. The contractor was Kier Regional Limited, and they started works in December 2003 under a letter of intent, which was drafted by Turner and Townsend, not a formal building contract. There were basically various kind of unresolved issues, like value engineering and pricing, which was the reason why work started under a letters of intent. And there was also then subsequently many kind of revisions to those letters of intent as well. So, but no building contract in place. So works were then completed in November 2004. They were delayed, but there was no building contract executed until after mediation in 2005. A dispute arose between Kier and the trust, and Kier contended that it was entitled to extensions of time and to additional payments in respect of the prolongation of the works, whereas the trust sought liquidated damages for around £750,000 for delay. But obviously there was no building contract in place. The trust sued Turner and Townsend for negligence. It alleged that if Turner and Townsend had acted with this care and skill reasonably to be expected of a project manager, it would have procured Kier's execution of the building contract, and that in those circumstances, Kier would have been liable to pay liquidated damages for delay, and the trust would have achieved a more advantageous outcome of the dispute with Kier. Turner and Townsend disputed this. It denied that anything it might have done would have led Kier to execute the building contract, contended that even if the building contract had been executed, the trust would have been in no better position in its dispute with Kier. And by way of a counterclaim, it sought payment of the trust of unpaid fees relating to the H5 works. So how did the court kind of what was decided in this case? So quite helpfully, the judgment was summarised quite succinctly at paragraph 10 of the judgment. Regarding kind of the duty of care, Turner and Townsend were found to have owed the trust a duty of care to exercise reasonable skill and care for the purposes of procuring from Kier an executed building contract. They were found to be in breach of that duty in that they failed to exercise sufficient focus on the matters holding up execution of the contract, or to exert sufficient pressure on Kier to finalise the contract. It was found that the breach of that duty caused the trust loss, because if Turner and Townsend had not been in breach of that duty, the trust would have taken sufficient steps to ensure that, as far as lay within its powers, it procured a contract. There would have been a real and substantial chance of Kier executing a contract that contained a provision for liquidated damages. And the existence of such a contract would have been a material benefit to the trust in its dispute with Kier when completion of the H5 works was delayed. So basically, regarding quantum, it was found that basically the probability is that if there'd been a contract in existence, the trust and Kier would have negotiated a reasonable settlement of their dispute. The value of such settlement to the trust, over and above the settlement it negotiated in the absence of that contract, was found to be of around £340,000, taking into account the probable price that the trust would have had to pay to achieve the execution of the contract. The trust was kind of entitled to recover 2/3 of that amount, having regard to the size of the chance that Kier would have indeed have signed the contract. Although the terms of Turner and Townsend's contract with the trust actually included a limitation clause, they couldn't rely on that because it was found not to have been incorporated into their appointment. But what they did do is they did recover £37,000, around £37,000 for additional fees on its counterclaim. So what kind of lessons can we take from that? So I think basically project managers need to actively consider pursuing formal contracts early. So avoid kind of over-reliance on letters of intent, as was the case here. Those letters of intent can severely limit kind of clients' protections, particularly for, as was the case here, with liquidated damages and exposure to disputes and delays. And I think project managers need to kind of identify and escalate things that are holding up the execution of a building contract. So here it was, for example, pricing, value engineering, and design. And they may actually have to apply pressure on contractors to finalise terms to make sure that they safeguard the client's interests. So project managers need to basically exercise reasonable skill and care to procure enforceable agreements, and a failure to do so, as was the case here, could lead to basically a negligence claim. And it's also advisable for clients to kind of clearly advise, project managers to clearly advise clients of the risks of not proceeding with a formal contract if letters of intent are kind of necessary in the circumstance, but obviously not advisable following this case. Right, so the final case I wanted to cover was the case of Sweet, which was Sweet UK Limited v Michael Wright Homes Limited. And this was essentially, so Sweet was an employer's agent and was required to arrange a performance bond from the contractor who later became insolvent. So the project related to to demolition of an existing factory building, the construction of 6 houses, and the refurbishment of a cottage in Somerset. Sweet, previously known as Cyril Sweet Limited, were appointed as Michael Wright Homes Limited's QS and EA. And the express terms of their appointment required it to, and this is key, prepare contract documentation and arrange for such documents to be executed by the parties hereto. So Sweet communicated to the contractor that a performance bond was required and tried numerous times to procure the bond. The judgment provided a chronology of all of the kind of events in respect of it, kind of taking kind of the various kind of chasers, etc., that it tried to seek to get that bond in place. And following unpaid fees, Sweet terminated its agreement with Michael Wright Homes. In September 2008, Sweet then commenced proceedings. The case was settled, save for Michael Wright Homes' counterclaim for failure to secure the bond. And in 2009, the contractor went into liquidation, and there was basically 3 points for the county court to decide. The first one was, did Sweet owe an absolute duty to ensure that a bond was provided, or was its duty limited to exercising reasonable skill and care? 2, was Sweet in breach of duty in relation to the provision of a performance bond? And 3, if Sweet had complied with its duty as identified in the first point, a reasonable skill and care obligation, would a performance bond have been provided by the contractor? So Michael Wright Holmes's argument was that basically they argued that either Sweet owed an absolute obligation to ensure that the performance bond was provided by the contractor, or even if there was no such absolute obligation, Sweet still had a duty to take reasonable care to see that the bond was provided by the contractor. They argued that Sweet should have at least withheld payment from the contractor in order to apply pressure on them to provide the bond. Whereas Sweet's argument was, they argued that there was no absolute obligation to ensure the contractor provided the bond. It was required to review and identify risks, and its obligation was to take reasonable care to ensure that the performance bond was provided, and that by making numerous requests of the contractor, they had successfully discharged this obligation. So what did the court find? So basically it was held that Sweet did not owe an absolute duty to ensure that the contractor provided the bond. The court kind of considered the definition of arrange, and found that Sweet's obligation was different to ensuring the performance bond was required. And if you look at kind of paragraph 47 and 48 of the judgment, they actually looked at the Oxford Dictionary definition of arrange, and concluded that arrange did not mean an absolute obligation in this context. Provided they put in place the necessary steps for the bond to be executed, which on the evidence they did, Sweet would have effectively discharged its duty to arrange under its appointment, and therefore any breach would be limited to the consultant's common law duty to exercise reasonable skill and care. Here, the kind of court noted the extensive steps that Sweet took in this case to try and secure the bond from the contractor. There's various emails, various meetings, and various chasers, and that was found to be sufficient to discharge the duty to arrange and to act with reasonable skill and care by making numerous attempts to secure the bond. So what were the key lessons here? So as I said, whilst this concerned an employer's agent as opposed to a project manager, I think the same kind of principle applies. And you really need to kind of look at the drafting of what you're actually required to do, both within the front end terms and within the scope. For example, here, the obligation was to arrange as opposed to insure a performance bond. And the court distinguished between an absolute and a reasonable skill and care obligation, and looked at the facts to discharge suite of any liability in this particular claim. So on this kind of final slide, I've kind of summarized what I think are some of the key lessons from the three cases, which, as I said from the start, I think is what the key kind of things that I want you to take away from this presentation. So check what your contract says and be clear on what's within the scope. So as was the case with the previous case we mentioned, it all centered on literally the drafting of arrange v insure. As we saw, absolute obligation differ from reasonable skill and care obligations. You need to kind of draft carefully and kind of document all steps to ensure compliance, just in the event that you find yourself at the end of a potential claim. You need to be proactive. Project managers need to be proactive, and you may have a positive duty, and you can't just act as a post box. So we saw that from the kind of Pozzolani case. So in that case, you may be required, depending on what's within your scope and what you've agreed to, you need to understand the insurance clauses and do more than just kind of forwarding certificates or acting as a post box. I know insurance is a particularly kind of it can get quite technical, and it's quite hard to follow at times and quite specialist. But if you are unsure as a project manager, seek specialist advice. So in that case, when I kind of the extract I took from the judgment, that judge said that in that particular circumstance, it was advisable to get the expertise of a broker or lawyers, or ask the client to do the same. And also, in relation to insurance, never make assumptions regarding kind of coverage. That was fatal in that particular case. And as we saw from that facts where he's the guy from basically the reference to him thinking that the insurance would probably cover the contractor. So I think the third lesson is kind of be careful with letters of intent. So an over reliance on letters of intent can be fatal. The client might need the protections that a building contract requires. Will need basically the protection that a building contract will require. And you really need to kind of escalate delays in pricing and design, and I think it's value engineering in that case, and you may have to apply pressure on them so that they can finalize terms. And if a building contract is not possible and you do need to proceed with letters of intent, consider warning clients of the risk of proceeding without a building contract in place, and record that advice. So yeah, I think they are the kind of key lessons that I think that we should take away from those cases. And I hope that's kind of particularly useful for the project manager on the call for us, but I think it's kind of interesting for those in the construction industry generally. I hope the kind of high level standards of care kind of section and the typical claims was useful. And on that basis, if anyone's got any questions, I think we've got another 15 minutes or so. So happy to answer any, or also happy to receive any emails if you got any questions when you come away.